Hi, my name is Yogya Bhatia and I'm a legal intern at LEXIS and Company. Today I'll be talking about FIR. The basic purpose of filing an FIR is to set criminal law into motion and not to state all the minute details therein. A first information report is the initial step in a criminal case recorded by the police and contains the basic knowledge of the crime committed, place of commission, time of commission, who was the victim, etc. The definition for the first information report has been provided in the Code of Criminal Procedure 1973 by the virtue of Section 154, which lays down that every information relating to the commission of a cognizable offence, if given orally to an officer in charge of a police station, shall be reduced to writing by him or under his direction and be read over to the informant, and every such information, whether given in writing or reduced to writing as aforesaid, shall be signed by the person giving it, and the substance thereof shall be entered into a book to be kept by such officer in such a form as the state government may prescribe in his behalf. The Honorable Supreme Court of India, while delivering its judgment in the matter of T.T. Anthony v. State of Kerala and ORS, laid down certain important points regarding Section 154 of the CRPC. Information given under subsection 1 of Section 154 of CRPC is commonly known as the First Information Report. Though this term is not used in the code, and as its nickname suggests, it is the earliest and the first information of cognizable offence recorded by an officer in charge of a police station. In another case, the court held that after all, the registration of FIR involves only the process of entering the substance of the information relating to the commission of a cognizable offence in a book kept by the officer in charge, as indicated in Section 154 of the Code. Who can lodge an FIR? FIR can be registered by a victim, a witness, or someone else with the knowledge of the crime. As per the laws laid down under Section 154 of the CRPC, the complainant can give information about the offence either in written or orally. In regard to who can file an FIR, the Apex Court of India has observed that Section 154 does not require that the report must be given by a person who has personal knowledge of the incident reported. The section speaks of the information relating to the commission of a cognizable offence given to an officer in charge of a police station. The police is obliged to read the FIR back to the complainant in case it is conversed to them orally to prevent the possibility of any differences in the oral and the written versions. Further, it is the duty of the complainant to report to the police station in person in case he had given the information on a telephone. Rajasthan High Court in the matter of Tuhal Singh v. State of Rajasthan has opined that if the telephonic message has been given to the officer in charge of a police station, the person giving the message is an unascertained one or is capable of being ascertained, the information has been reduced to writing as required under Section 154 of CRPC, and it is faithful record of such information, and the information discloses commission of a cognizable offence and is not cryptic one or incomplete in essential details, it would constitute FIR. However, in a case wherein though the police officer went to the scene hearing rumours but recorded a statement at the police station, it was held that in circumstances of the case that statement could be accepted as FIR. The police are required to give a copy of the FIR to the complainant free of charge. Providing a copy of FIR to the accused. Under Indian criminal law, the informant, as seen earlier, is entitled to get a copy of the first information report lodged by him at the police station free of cost. It is necessary to document in a criminal case and can majorly support the case of the informant or the victim. However, the accused person is also entitled to get a copy of the first information report. Section 207 of the Code of the Criminal Procedure entitles the accused to get the copy of the first information report. The investigation has been completed by the police in the said case and the charge sheet has been filed in the court. The provision states that the magistrate in such circumstances must furnish to the accused a copy of the FIR free of cost. Further, on analysis of Section 173, subsection 5 and subsection 7 of the Code of Criminal Procedure 1973, it can be easily implied that the police station may also provide copy of the first information report to the accused free of cost after filing of the charge sheet. The essential prerequisite of both the Section 207 and Section 173 is that the police must have filed the charge sheet in the subjected matter. There have been some cases where the court has provided the accused with a copy of the FIR even before filing of charge sheet and on his request and a payment of a certain fee. Under the Indian Evidence Act 1872, Section 74 lays down the definition of a public document. In many decisions, the court in India have held the first information report to fit within the definition of public document and hence have held that under Section 76 of the Evidence Act, certified copy of the FIR has to be given to the accused person on his request on payment of the applicable legal fees by every public officer. The decision of Allahabad High Court in the matter of Shyam Lal was the state of UP. Karnataka High Court's ruling in the matter of Chinnappa and Narappa was a state, and the decision of the Bombay High Court in the case of Mohammad Khalid Sheikh was the state of Maharashtra, are most cited judgment in this regard, where the courts have held that the FIR fits the definition of public document under Section 74 of Indian Evidence Act.